Hello everyone, welcome to Dream UPSC. So today's topic of discussion is Protection of Children from Sexual Offences Act. Why we are discussing this act? This act was recently in news, that's why we are discussing this act. So what was the news? The news was Supreme Court had to inject an interpretation of skin-to-skin contact given by Bombay High Court. That means Supreme Court had to issue an legal interpretation regarding the skin-to-skin contact. So in today's video, we're going to discuss about this act, the pros and cons of this act, and what is the historical child sexual abuse and what are the way ahead so that we can, limit down the sexual offenses cases. This is my Instagram ID and you can use this Instagram ID to get in connect with me. Let's start the video. Now what is the Protection of Children from Sexual Offences Act 2012? This particular act has been enacted to protect the children from sexual assaults and the sexual harassment and pornography. So this was the basic idea behind the enactment of this act. This particular act also provides the healthy physical, emotional, intellectual and social development of a child. This act provides the definition of a child. A child is a person that is below the age of 18 years. That means all the persons that are below the 18 years of age considered as a child. And this act gave us a limit of 1 year, maximum time limit of 1 year, so that the case must be disposed. That means the case must be disposed of within 1 year from the date of offence is reported. So these were the basic provisions under the act. Now 2019 amendments are made in the previous act of 2012. Why there was a need of amendments? Now we will see the provisions of 2019 amendment. So there were three provisions that were provided under the 2019 amendment. So the very first one was there was a more stringent punishment regarding the death penalty, or we can say the fine. So this was the first provision. Now the another provision was there was a term introduced, that is penetrative sexual assault. Now this was the second one. Now the third one, the another term has been also introduced, that is aggravated sexual assault. What is aggravated sexual assault? Now we will discuss about this aggravated sexual assault. When a child is mentally ill and the abuse is committed by a person that is familiar to that children and whom a children or a child can trust. This person could be a family member, a police officer, a teacher, or as a doctor. So these were the three provisions brought under the 2019 amendments. Now what is historical child sexual abuse? When a case is reportedly late, that means when incidents happened in a past but due to some reasons that incidents reported late, that will come under the category of historical child sexual abuse. And the reasons behind the reporting and the delayed reporting of cases could be the trust issues. That means a child is unable to trust his or her family members, the police officers. So these were the basic reasons behind the late reporting of cases. So where the fundamental problems lies. Now the topic is what are the drawbacks of laws and rules that are mentioned in our CrPC, we can say in our IPC or in a POCSO Act. So there is a delayed reporting. If there is a delayed reporting, then there won't be an advance prosecution. That means the advance prosecution of a case is totally dependent on the delay reporting. If there is a less delay in reporting, then there will be advance prosecution. Now we have less than 5% chances for gathering the direct physical and medical evidences in such cases. If there is a delay reporting, then there is a 5% less chances than we can get or we can gather the physical and medical evidences related to that historical case. And there will also be a lack of procedural guidance. If there is a late in the reporting of a case, obviously there will be less of documentation, so there will be lack of procedural guidance as well. So UK has enacted an act in 2003 to assist the police in such cases. So India also needs such kind of steps to reform or to revive its laws and rules related to child sexual abuse. So in 2018 there was a news. What happened in 2018? There was a survivor, there was a child sexual abuse survivor that filed an online petition regarding her sexual abuse, but the survivor got tremendous support. The survivor got tremendous support, but she failed to get traction with the people. The people and the police do not filed her case. So what she did, she raised an online awareness campaign, and this was the case of about 40 years back. In 2018, the survivor registered a petition, and the petition was getting tremendous support, but the police didn't file any report. So what she did, she raised an online awareness campaign. Then the Women and Child Development Minister went to the Union Minister of Law and Justice, and the Law and Justice Minister said there is, and clarified that no time limit will be there for POCSO cases. In such cases, in the historical cases, there will be no time limit for the registration of the cases. So this was all about the 2018 case. Now what ahead? What is the need of no time limit shall apply for POCSO cases. Now, if I take an example of CrPC, Criminal Procedure Code, there is a provision in CrPC that says it prohibits the judicial magistrate from taking cognizance of cases beyond a specific time limit. That means a judicial magistrate can take the sexual abuse cases or historical child sexual abuse cases in this particular time limit. And the another example also we have our IPC, and there is a provision and there is a section in IPC, that is section 354. This particular section says that reporting of an offense would be barred by CrPC if reporting is done after more than 3 years of the evidence. Also the CrPC gives us this particular time limit. So here in CrPC and here in IPC we have a time limit. Now we have the accommodation syndrome. Now what is this particular term? This particular term has been evolved by the Roland C Summit, right? And what is this particular syndrome is all about? When a child keeps the secret within herself or himself because of fear or due to some another reason that no one gonna trust him or no one gonna trust her, that's why a child keeps the secret within herself. This particular behavior is known as the accommodation behavior. Now we have seen how UK has enacted a law in 2003 for the historical child sexual abuse. So India must need to revise its procedures, and India need to enact such kind of rules and such kind of laws. There is an urgent need to reform and revise our laws such as the CrPC time limit and IPC limit, and also our IPC and also our POCSO Act. Whereas there was an amendment in 2019, but we can also revise and reform our POCSO Act as well. So this was all about the lecture. I hope you have learned something. So thank you so much guys, and please do subscribe my channel, that is